So let me do that and launch that poll. So have you seen the movie, My Cousin Vinny? Awesome. All right. Well, I'll end the poll and share the results. So one of us has seen it, so this will be redundant for you, but the rest of us have not. But what I like about this movie and these two clips in particular is it actually shows like the voir dire process, basically. So thank you for answering that. So basically what voir dire is a process in which the judge and the attorneys get to like talk to prospective jurors. And usually they're trying to ask you about your background and any prejudice. Typically, and also here, if you are an expert witness, you're part of that process, and that is what you see in the videos. So I think I have the videos open here. So you'll see, let me stop sharing that. And so you'll see that it's only like a 2-minute video here and another 2-minute video here. And Melissa Torme is like the one that's shown as an expert witness in more automotive. And probably, you know, by the look of her, the other attorney is like, no way, like that's the other attorney, not there. I had a, there we go. That's the opposing counsel. So, so after class, if you can, I think it would be fun to watch this video. And then let me go back and share the notes, because voir dire is, you do get one exemption where you can eliminate a juror without any reasoning. Typically, then after that, you do have to eliminate a juror for, you have to eliminate the jury. You have to have some type of reason. You have to show that that typically you have to show some prejudice is what happens. Now, has anybody, let me look in the chat, has anybody served as a juror? Or like you've been called for jury duty and served as a juror? Yes or no? No, okay. I see one no, that's cool. Me neither. I've been, no, yeah, no. I know, me too, no. Like I've been called to jury duty and I go there and I'm usually not selected either. Well, now, have you gone to jury duty? Like, have you been called on jury duty for your civic duty? I haven't been called in Pennsylvania yet. And so this is my 8th year. No. Interesting. Yeah, right? No. Oh, we've all been lucky. Woohoo. No, but oh, my boyfriend has been called twice and both he has not been selected. Yeah, see, I've been called a couple of times in Florida and I wasn't selected either. So I think that may be a good or bad thing. I have had some friends that have been called and selected, and some of those trials were like 3 or 4 weeks, so it was like extensive. So that is interesting. So, and I think usually once, because they have you fill out like a form, at least in Florida they did, and then I put in all my education, and usually then I'm sent away, which is good or bad, I guess. So we'll see now. So definitely, I would say after class, take a look at these videos, and then you have this document in D2L. And then the other 2 things I wanted to emphasize were expert witness and Doppert challenge, and lastly, some evidence, because I think those are the main thrust of this chapter. And I just want to make sure that you know, because the expert witness, like I mentioned, if you are Doppert challenged, then that's a problem, right? Because what they're saying to you then as an expert witness is that they don't really trust or actually think that you have a valid expert testimony and that you can't arrive at an opinion that is of the expert level. And so, and typically once you're Doppert challenged, you're kind of done for in the profession. So any party can initiate your Doppert challenge, but usually the judge decides. Most of the times what I've seen is that one counsel will Doppert challenge just to probably get a rise out of you as an expert witness. Thankfully, I've never been Doppert challenged, but like I mentioned, I think that we had a guest speaker once that was a former IUP, well, she's an IUP alum, and she was Doppert challenged, but it was completely moved out. And that's one of the two ways in which you can be challenged. The Doppler challenge is really like the worst. Then typically you get cross-examined, right? So as an expert, what you're hopefully going to do is you're providing an opinion, but hopefully based on the evidence, right? And you can do what other witnesses can. And we have rules of evidence, and that's why I included some of that in the end of this document here. But as an expert person testifying, you're able to state your opinion, and you can have it first to testify, and then you can have the data. I have found in my experience, when you have the data, it works a lot better. And then again, you want to make sure that your testimony is coming across, that you're able to explain it, and hopefully your cross-examination will be a lot less, but I highly doubt it. Attorneys are annoying, in my opinion, and so they just want to try to get a rile out of you. Never lose your cool on the witness stand. Never roll your eyes. Everything that you do is being watched, if it's a judge or an arbitration or a jury. And with a jury, you never know. I mean, you never know if it's 10 or 12 people, you just don't know how they're going to react. And then when it comes to evidence, you as an expert witness are able to submit evidence. But again, it has to be based on facts or data. And I'm going to show you the short and long report of the ACFE forms so that you have that. And it also has to be based on reliable principles and methods, which typically, if we're using data analytics, or if we're using statistics, that is in and of itself okay. Or if we're using GAAP, or if we're using IFRSs, then that is all legitimate. And these principles and methods, right, we have to show that it's consistent with what's under the case. So if you are looking at investments, you need to make sure that you're looking at the newest, the latest and greatest investments within, that. And also, I wanted to, let me just show you this. As you know, if you go to my website, this is our course, Forensic and Internal Accounting. So everything that I probably linked in D2L is here. This is, unfortunately, I didn't put this in order. I don't know why, because I ended up doing a lot of items here. But here, if you click Access Lesson, you'll see all of the videos for this chapter. And I tried to do it, especially Doppler challenge and rules of evidence, and you'll see a lot of the same aspects that we've been covering, but just so that way you can have that as well. And then I added the notes in our D2L course. And we have to be a member of the ACFE to get a lot of these documents. If you are considering a career, or even if you're not, I think it's a very nominal fee to be a student member. So I would recommend that, so you can get access to all of these resources. These are just proposals for a fraud examination here. So if you look at it, it's just like an engagement letter. So very similar to what we would do for an audit engagement letter, except that the audit engagement letter has more prescriptions in there, and it tells us exactly what we have to say. Here we have a lot more leeway, as you can see. And so it's a lot less cumbersome, I would say, than an audit engagement letter. And if you've interned for an audit firm, you know that all of the Big Four and a lot of the other firms, they have like their own policies. And typically it's just a canned document when it comes to audit. But with a fraud examination, I tend to use the fraud examination proposal as a guide, and then I add additional documentation and additional information that I would like. And the same thing if you're doing a policy review. So a lot of organizations now, to comply with SOX from the AICPA, do some type of review. And this is another aspect of that. And so you'll see those too. But the key is the end result of what you're doing in terms of a fraud examination or in terms of expert witnessing are these two fraud reports. So let's start with the short report here. So here what you have is, the key is to note the section. So you will have a background section and an executive summary. Typically, this is what most people read if you give them this, except your attorney and the judge probably. But typically, if it's a jury trial, most jurors just admit to just reading this two information and the findings or the damages that you're asking. The scope is what you're actually going to do. The approach, this is where you have to get very detailed. Again, this is going to be the only probably exhibit that you as an expert witness are going to provide. So basically you want to make sure that you have all the information here. And then I'll show you the short report, which is kind of what you're doing in terms of writing it. And then the long report is where you have a lot of your evidence there. So you mentioned who you interview and you mentioned the findings. Again, I would say the scope, the approach, approach, and findings, but mostly the approach and the findings are going to be where you're going. It could be as long or as little. Just because it says it's a short report doesn't mean it has to be short. It's just you want to make sure that you have everything in here to kind of prove your case. And the better your report is, the more likely you are to win, the better your data is succinct and that you can show sequentially how it did lead to the actual fraudulent behavior, then you will see that here. And again, specificity, any type of numbers that you're given, you want to make sure that you have exhibits underneath it to show it. And that would be in the long report. And so then you see everything that they've looked at. And also if you've hired a private eye, you would put it in here in your approach and you would put the findings in there. If you've gathered all the evidence that you gathered, you might do that as another listing and a table. That's my, recommendation. Your summary is basically what you're looking for, and then the impact is pretty much your damages. And if you're asking for punitive damages, you want to make sure, and then also you want to show your calculations. In my experience, that's what I have found to be, the make or break of any case. And so you see that, and then you see what sections are optional up here if you want recommendations. If we were usually hired for a fraud examination, and most of the times I would say we do issue recommendations because it's our client, and hopefully we can then have a follow-up engagement to look for fraud deterrence once they actually implement your recommendations, which are usually additional internal controls or additional ways to safeguard against the type of activity. If it was fraudulent, then you would be hired as a, like fraud policy review, or you would be hired for, to see if you can penetrate the system, to see if they're actually working. So that is the short report. And then if you come back into our AFC documents, then you have the long report. And the only big difference here is you'll see it's usually the same types, like you'll have a lot of these supporting documentation. So this starts with what you've done in terms of, like what you've done and like an overview. So this is more like the executive summary. And then you look at all of your details here, but then it can get, you always have to have an index to your report. And then you kind of give all of the documentation that you have to support your case. So typically we do the short report to kind of overall solidify our findings, and then the long report we give all of our supporting documentation. You can do it as one as well with exhibits if you so choose, but I have found to keep like a list of the exhibits, so similar to what you see in some dissertations or in some documents, like and then typically if your exhibits, usually if you can have it electronically, I love it the best, of course, but sometimes attorneys are very against electronic. There are a lot of pen and paper, at least that's what I found. So then you have this big binder with all of your exhibits in there, and then usually I try to memorize them, so that way when I'm on the exhibit stand, like I'm on the witness stand, I can easily go back and forth. And by the time you draft and redraft all of this and redraft all of your memos, you'll see all of the invoices and all of the documents. And then what I like to do is put tick marks on them. So what I've done, so what I'm able to show that has been verified. So very similar to an audit, but then the only piece is that you are showing, points where there is some deficiencies to hopefully prove your fraud. And you see, mostly it's made of your memos based on your discussions. You can also try, and we're going to talk about more interviewing skills later. You can try to interview and videotape those interviews, and then you can have them transcribed so that you have a word for word depiction. Also, when you are deposed, make sure that you review your deposition, because sometimes if you can gloss over it and they might add the word not in there. And technically you didn't say that. So you want to make sure that you go through that with a fine-tooth comb, especially because then if you, God forbid, that word not came in there, and then when you're on the witness stand, you didn't say it. And then it's like, oh, well, when you were deposed, you said this. I've had that happen to one of my colleagues. Thank God it did not happen to me. but basically that can also make you lose a case. So you see all of this information there. So I would say think of the long report as a little bit of a synopsis, but mostly your exhibits. I usually tend to draft the short report and then use the long report format type to just have all of my exhibits. So let me stop sharing there a minute. Any questions on? Excellent. All right, let's launch the poll and let's get started. Great. So which of the following is an example of sanctions that we would give in a civil case? Our choice is D, which is correct. Compensation for economic damages, that's usually in a civil case. Excellent. Great. Now let me see. Let me just sharing and stop share or start sharing. Hopefully you see the question. And let me relaunch our poll. So which of the following best describes civil justice? Our popular choice, which is justice between parties to a dispute regardless of their larger principles. Not so much. So we had a few select B, which was correct. It's your private affairs. So keep in mind of citizens and your rights. So when you're thinking of civil, remember, criminal justice is you've actually committed some type of, offense, a crime. But when we're looking at civil, justice, think of it from your citizens and from your perspective, like your own private affairs and your own rights and your freedoms of speech and your protections, such as like equal treatment, race, sex, all of that stuff, which I think has been in the forefront of the news lately. But that's okay. We will get it right. And justice fairly administered according to the rules of substantive law. That's for a fair trial. That can actually happen to both criminal and civil defenses. But in this case, just think of it, because we're talking about civil justice as private affairs of citizens and your respective rights. But that's okay. We'll get it right on the test. So let me stop sharing those results and then let me go down here to the bottom, see if this works. All right, good. So you're still seeing a preview of the question, I hope. Okay, I think so, because people are answering. So which of the following forms of justice is fairly administered according to the rules of statutory law? So let's see. So we were at a tie between B and D, and then B edged out, and it's substantial justice. So when you're thinking of statutory law, that's that it's fairly administered. So remember that last question at the end, that last example there, that's what we're talking about here. So make sure you put in your notes or your study guide, because your test is open book, open note. Substantial justice is where you're fairly administered according to the rules of substantive law, which is that you get that fair trial. So just make sure you do that. No problem. That's why we do them here together, so that we're all on the same page. Excellent. So let's go back. Following, if identified, can result in a mistrial. And let me relaunch our poll here for this question. So we have our popular choice as A, which is correct. If you are a juror and you're following polls from the media, one of the first things they tell you is you can't look at it. Usually you're kind of sequestered depending on how highly profiled it is. And so that is definitely grounds for a mistrial, so that you can know what the media is saying or what other people's opinions are saying. That definitely violates the rules of evidence. That could be challenged if opposing counsel found out about that. Here we have if the defense attorney concealed his client's drinking habit as he felt it would be prejudicial to the client on the case of banking fraud. Well, banking fraud, you kind of stole money, so it really doesn't have much to do with drinking. So again, only facts to the case would be presented. Now, sometimes what attorneys do in this case, it would let it like opposing counsel will let it slip out, and then it would be an objection and it would be overruled. But then that is already in the minds of the jury. And then here we have an expert witness stated an opinion on the evidence without first relying on the underlying facts. You can state that opinion first if you so choose. I would probably recommend against it. And sometimes we as expert witnesses do that to get the wow factor, like this person is guilty, but be careful because they can always sue you for, libel and slander and all that great stuff. So I would say, but you can say, the evidence suggests and give your opinion first, or I believe so-and-so did this, and here's the evidence why. You can do that too. So that's still okay. Awesome. So some of us got that right, which is great. So let's go to the next one. We have Igor, who's a wealthy entrepreneur, was involved. Let me relaunch the poll so I don't forget. Was involved in an embezzlement of cash from the office, and tax evasion. If discovered, which of the following will he be charged under? Most of us liked A, which is criminal law, and that is correct because of the embezzlement. So excellent. It's not civil law because of the embezzlement. So that's okay. We'll get it wrong here and get it right on the test. So long. Okay. So as I told you when we were doing our class activity last class, that you should know which of these it is. So which of the following rules of Federal Rules of Civil Procedure limits our discovery of the expert's communication with engaging counsel and any report drafts that may be in the poll and share our results? So we had B and C. So it looks like B and C. And in that case, it is B. So it's rules, so you may want to write this down, Rule 26B4 of the Federal Rules of Civil Procedure. That's what limits the discovery of an expert's communication with engaging counsel and any report drafts that they have to prepare. And also it limits any discovery of facts and opinions that we as the expert hold when we're engaged to assist our counsel in the trial preparation. And even if we're not expected to be called as a witness. So 26B-4, we did look at A2 and A1. I think it was B. I think we looked at, I forget the numbers we looked at. We looked at 2 cases. But you want to make sure that you note that. And I would probably just have a listing of all of them as your gen. So which of the following is the difference between a criminal and a civil case? And let's all right, so we have our popular choice as B, which is correct. So the difference between a criminal and civil case is a defendant has an amount of time, 20 days, to respond to a complaint in a civil case, whereas he or she would enter a plea in the charge during their first appearance of a criminal case. So typically you have to say guilty or not guilty, whereas if you have a civil case, then you do have to provide a response. And then failing to file a timely response can result not necessarily into a default judgment, whereas failing to timely respond, it would be a declaratory judgment. Not all the time. It can, but not all the time. So the correct answer here is the responses that you're giving. Either you're responding to a complaint in a civil case, or you're pleading guilty or not guilty if you're in a criminal case. Excellent. And as you can see with the legal testifying expert that failed to include changes to the case, and they were not previously presented in his report, and he is expecting that this information will be offered at the trial. So which of the following rules of Federal Rules of Civil Procedure did he violate? And let me relaunch the poll because I forgot to do that. Justice has to keep me on my toes. Thank you. I keep all over the place, but the correct answer is C, which most of us got, which is 26E1, which it does require us as an expert that we always have to supplement our reports if we're going to see any changes to that information, and we have to present it, especially if we're going to bring it up at trial. So we are not only required to produce the report, but we're also required to change the report. And if you don't do that, then the report could be the report could be inadmissible overall, and your testimony would be stricken most of the time. And that's usually what opposing counsel wants to do. So we don't want. So let me relaunch the poll here to allow you plenty of time to answer. So the trial stage of a legal proceeding involves a voir dire process. And what does this process involve? So our popular choice was D, which is correct, right? Where you, the judge, the attorneys are looking at prospective jurors about their backgrounds and beliefs. I know this process is where you're actually summoning a jury for potential jury duty, but the actual voir dire process is where you're asking those potential people that you've summoned for jury duty, like, hey, what are you thinking? How are you thinking it? And we're not presenting any evidence when like the actual, as a forensic accountant, we only present evidence during some type of trial. It could be a trial, it could be an arbitration, it could be a judge trial, it could be a jury trial, whatever it is, but we're not usually presenting evidence at that point. That's okay. All right, I think we have time for a couple more, maybe one or two more favorites. So which of the following statements is true of the standards of proof? And let me relaunch that. So our popular choice would be, wait 1 second here, which is correct, right? In a civil case, what we need is a preponderance of the evidence. Here, beyond a reasonable doubt, that's for a criminal case. And that is more, right? And so basically, but for just a civil case, you just need a preponderance of the evidence. And then if you think, I think we had in the PowerPoint, I know it was in the book, like a nice gauge there that showed you where. So beyond a reasonable doubt is probably at the top, but that doesn't necessarily mean that it is clear and convincing. You know, it's just the type of evidence that you're presenting. So when we're thinking of a civil case, it's like, you know, more likely than not. So greater than 50% probability if we want to get statistical on that. Excellent. So let me stop sharing here and stop sharing. So that's a little bit of what you will see on your exam for this chapter in particular. And awesome.